No contest clause. What is it, and how does it affect your estate plan? Creating a last will is your opportunity to decide precisely what happens to your estate after death. In most instances, that is exactly what happens. Sometimes, a challenge to the validity of the will is filed. If the contestant is successful with that challenge, the will is declared invalid, and the estate is probated using the relevant state intestate succession laws. If the contestant is not successful, the probate of the estate continues using the will submitted. Either way, litigating a will contest is costly and time-consuming. Understanding why people often include a no contest clause requires you to understand the effect a contest has on the probate of an estate. Following the death of the decedent, the executor of the estate submits an original copy of the decedent's last will to the appropriate court along with a petition to open probate. The exact process and procedures will vary by state. However, at some point shortly thereafter, the court will decide that the will submitted for probate is an authentic one signed by the decedent, and the probate process moves forward. In the interim, an interested party may decide to challenge the authenticity of the will by filing what is referred to as a will contest. The validity of the will must then be litigated. The litigation often takes months to resolve. Because the executor is required to defend the will, it also costs the estate a considerable amount of money. If the will contest is successful, the will is declared invalid, and the state intestate succession laws are used to distribute the assets. If the will contest is unsuccessful, probate resumes where it left off using the terms of the will to distribute the estate. The clause adds to a will that effectively disinherits anyone who challenges the will. For it to work as intended, the contestant must receive something in the will, or there is no incentive to move forward with a challenge. For example, imagine that you have 2 children and that your estate is worth $5 million. You are concerned that your son might challenge your will if you leave him nothing, so you leave him $500,000 and include a no contest clause in your will. That $500,000 is considerably less than the half he would normally inherit. However, it is more than nothing. Your son then has 2 options. The first is to take the $500,000 and not challenge your will. The second is for him to risk losing the $500,000 by filing a will contest. If he does contest the will and is successful, he would inherit half the estate. However, if he is unsuccessful, he forfeits his $500,000 inheritance because he contested the will. Individual states treat no contest clauses differently. If you have additional questions or concerns about using a no contest clause in your will, contact Schomer Law Group by calling 310-337-7696 or info@schomerlaw.com for more information. And don't forget to hit that red subscribe button so that you don't miss any future videos.